Hello, everybody. I guess we can start. Can you hear me okay? Everybody can hear? Okay, great. If you can't, we can do something with the microphone. Well, thank you all for coming, and we appreciate it. This is our 2014 Employment Law Update. How many of you are employers? Why? That's a good question. You know, we like putting these programs on and educating all of you, but what's kind of discomforting is to see all the sad looks on your faces as we go through this there, when you realize, oh my goodness, that California has enacted 800 new laws this year. Many of them are employment related. Couple that with the 800 the year before and the 800 the year before that, plus the federal laws, it becomes overwhelming, and you are presumed to know all that stuff. It's never an excuse, ever, to say, gee, I didn't know that was the law. So you need to know that. My name is Roy Schneider. I'm a partner of Schneiders and Associates. We're putting this program on with my son Ted Schneider. We're a business law firm, do employment, business, estate planning, real estate. And I want to thank the Ventura Chamber very much for hosting this for us. And SCORE, we work very closely with SCORE. They volunteered and had some people come help us with this, which is, I really appreciate that. We're going to give you a lot of information. You have your handouts. Take notes. Most of this stuff will apply to you. Some of it will apply more. Take notes. Feel free to call us later, email us, and if you have specific questions. We're not going to be able to go into great detail on all the new laws, but we'll give you the overview, and you'll be able to note what's important to you. I want to apologize in advance. I have a cold. I'm medicated, and I'm surly. So, be careful. I'm also sleep deprived. Last night I taught my business ethics class at Laverne University. And it's, I teach business ethics, and it never fails. I started a couple weeks ago. There's always some student in the class, first day, raises their hand and goes, how can you teach us ethics? You're a lawyer. I have to tell them, oh, just do as I say. But, as just an aside, not necessarily law, we deal a lot in business ethics with employment relations and employees, and we see a lot of lawsuits by employees. It is burgeoning. It's overwhelming now. It's all lawyer-driven, and if you fire an employee, they're going to get a letter from a lawyer saying, oh, have you been terminated? Have you applied for unemployment? Your boss mean to you? We can sue. It's rampant. But one of the common threads among a lot of these lawsuits is the employee's perception that they weren't treated well. They weren't treated fairly, with dignity or respect. And there's many things a company can do outside of the law to avoid lawsuits. And so one of those, if you ever want assistance on that, how to handle employees, the termination, the discipline, there are right ways and wrong ways to do that, and we can certainly help with that. Actually, I saw yesterday there's a law just introduced in California. I don't know if it'll pass. It could be. It's actually called the anti-bullying law in California for employers. Right now, you don't have a right to a civil workplace, to civility, to people being nice. You don't have that right. If somebody picks on you, if somebody's mean to you, if it's based on a protected class, they're mean to you because of your religion, your race, your gender, then you have a claim. But not just because they're mean. Well, the anti-bullying legislation will it'll make it unlawful to subject employees to abusive work environment not related to a protected class. So now, just because somebody says, gee, they're mean to me, and my boss is a bully, may have a claim. I'm assuming Governor Brown would veto that, but we'll see what happens with that one. It's kind of interesting. Okay, this is something new. I don't know if you've seen these things before. Are you familiar with Prezzies? Prezi? Have you heard of Prezzies? You've heard of PowerPoints, right? Well, PowerPoints are so 2013. They're done. The new trend for everything now is Prezi. You'll see the difference, and I think you'll like it. It's kind of cool. Ooh. Isn't that cool? That's a Prezi. So that's what you're going to see now from new people. This is kind of interesting. You'll have no idea of this. You'll be kind of amazed. This was a party. So I'm sure some of you had holiday parties. Did any of you go to your company holiday parties? Oh boy, what places you work for? No parties? Because of this? Parties are out? Well, it could be. Well, this was Marriott had a party. They had a 2-drink minimum. They gave you, a 2-drink minimum, 2-drink tickets they gave you. They gave you 2 tickets, and this one employee came with a flask full of alcohol, got his 2 drinks, and kept having the bartender fill up his flask. He got, pretty drunk, drove home with a coworker, drove home, stayed home for a little bit, then drove to take the coworker home. On that trip, he ran into somebody, killed him. They sued the employer. Sued the employer. Now, there's interesting in California, we have a social host statute that does not make you liable if somebody gets drunk in your house or drunk at your party and hurts somebody. It's a statute. So they can get drunk in your house or drunk at a party and go, you're not liable by statute. So they couldn't sue the employer for being negligent, right? But employers are liable under the theory of respondeat superior for their employees' actions within the scope of their employment. This was a holiday party. The court said this was a holiday party which was benefit the employer because the employees come, they get happy, it builds morale, so therefore it was in the scope of employment. And the employee was negligent by drinking too much. So employers are liable for the negligence of their employees in the scope of their employment. So being at that party was scope of employment. And it didn't stop when he went home and drove again. And the employer was liable for that, which is kind of scary. Normally we have the coming and going rule. Are you familiar with that? Like on your way to work, if you hurt somebody, you're not liable. On your way home, if you hurt somebody, the employer's not liable. This is an exception. Right? And another one, similar, this is a little scary, the company car. You might have employees that have their own cars. And part of their job, they drive, right? They drive around as part of their job. They have to go visit customers. They have to go pick up supplies. Okay? If the employer receives an incidental benefit from the use of that car, that is deemed a company car. And that is an exception to the coming and going rule. So in this case, a young lady was going home, stopped at a yogurt shop on the way home, and got yogurt, and left the yogurt shop and hit a guy on a motorcycle, killed him, and the family sued the employer. And the court said the company derived an incidental benefit from that car of the employees, therefore she was in the scope of her employment, coming and going, because it's a company car, and the employer is liable. Now, in another case, similar, the employee was driving home, same kind of a car situation, but went 300 miles out of the way to go visit somebody and do some stuff there, and got to an accident there. In that situation, they said the company was not liable because that wasn't even foreseeable. That was not foreseeable. There's always this element of foreseeability in tort claims. But driving home and stopping for some errands is foreseeable. So think about that. Talk to your insurance brokers. So I got employees who drive a car. Some companies have now switched to buying company cars and say when you come to work, you have to go out for the company, you have to drive the company car. Because if you drive your own car, now we're liable. And there's some speculation that what if you're on the weekend driving your car that you use for work? Can the employer be liable? So it's kind of interesting. All right, so that's kind of cool. Class actions, we'll talk quickly about this, and arbitrations. There's been a lot of cases in the last few years on arbitration, mandatory arbitration, between employers and employees. Telling your employees, if you have a claim, it has to be arbitrated. You know, a number of courts in a number of states have gone back and forth whether that's fair, whether you should be able to do that, because not allowing an employee to go to court is a hardship on the employee, because it is. California, basically the latest California case said that arbitration agreements can be valid if they're not unconscionable. So you have to look at them. They've got to basically provide for fair procedures and not be so heavy-handed and one-sided. There has to be consideration for it. It's things to think about. So if you want arbitration in your agreements, you should look at it, and we can help you do that very carefully. Oh, one of the things I just want to mention, that a lot of the problems we see now is because the employers did not have good policies in place, and their handbooks were out of date. So one of the things that can help you a lot is to have policies and an up-to-date, great handbook. And the laws change so fast, if your handbook is more than 2-3 years old, it's out of date. Okay, and that helps a lot, because that's what the courts look at. What's your policies? Our policies are kind of unwritten, doesn't help. And it's not in the handbook, doesn't help. So that's important. So arbitration is an important deal. The other thing is, Class actions, this is major stuff. A lot of companies, you have 100 employees or so, you could be worried about a class action. Class action wage and hour cases that go back 4 years, you could be talking 500 people. Wipe you out, put you out of business. So you can have in your agreement with your employees, perhaps, you agree, any disputes, you will arbitrate it, and you will not be part of a class in a class action. AT&T is doing that now, Verizon. You sign up contracts for phone services, it's in there. And the U.S. Supreme Court has upheld it for consumer contracts, which is interesting. Well, the U.S. Supreme Court dealt with this theory, the economic vindication theory. The reason there was class actions is because, for example, if AT&T overcharged you, 12 cents, you're not going to sue them. You're not going to sue them for 12 cents, right? But if they overcharged, 30 million people 12 cents, that's a lot of money. And the only way you can bring some action to stop that is a class action. Because the lawyers aren't going to do it for, 30% of 12 cents. So the U.S. Supreme Court says, interesting, a case brought against American Express in an antitrust by merchants who had relatively small damages, $2,000 to $3,000 each, saying all the law has to do is afford you a remedy. It doesn't have to afford you an affordable remedy. And that was big in the employment contracts because the employee owed you, $2,000, $5,000, overtime, whatever. Very difficult. You're not going to get a lawyer to help you. You've got to go figure out how you do it yourself. But if there's 100 employees, 200 employees, lawyers would do that. But now there's no right to affordable remedies. Kind of interesting. We'll see how it plays out in California. There was, a little while ago, the National Labor Relations Board, this D.R. Horton case, they invalidated, National Labor Relations Board invalidated class action waivers. They said that violates the National Labor Relations Act, which says that employees can get together and protect their rights as employees. Courts are striking that down. California now, the California Supreme Court is actually looking at the mandatory arbitration clauses, the class action waivers, and this economic vindication theory. So we'll learn more about that. But if you want those kind of things in your contracts, it's important to get it done right. Good Samaritan employer. It's kind of an oxymoron, but employers can be nice, I guess. I don't know who comes up with these laws, but this is a bill in the Health and Safety Code that prohibits an employer from adopting a policy that says you cannot provide emergency medical services to somebody, like CPR. I guess employers are concerned that if somebody gets a heart attack and one of their employees tries to do CPR and injures that person further, they'll get sued. So some companies have had policies, you cannot render emergency assistance. However, you can adopt a policy, and this is kind of funny, you can adopt a policy that says you may render emergency assistance if you are properly trained to provide that service. And if nobody is properly trained, then you can do it anyway. Okay? So the policy doesn't mean much. So be careful about policies like that if you want to do that. That's kind of interesting. This is kind of interesting. Yeah, this is kind of cool. To be exempt, and Ted will talk more about that, to be an exempt employee, exempt, that means you don't give them overtime, rest breaks, work them, 40 hours a day. Only lawyers work 40 hours a day. But, all right. And this was interesting. So you have to pay somebody twice minimum wage, right? To be exempt, they have to get twice minimum wage. So this was kind of a guy that he got paid $29 for every hour he billed. He was an insurance adjuster, and he billed time to his clients. And he got paid $29, which is more than twice minimum wage, for every hour he billed. That was his contract. He billed way more than the twice minimum wage standard, made lots of money. He brought a suit because they treated him as an exempt employee. One of the key requirements of exempt employee is not just twice minimum wage, but a guaranteed salary. You have to have a guaranteed minimum salary. That's twice minimum wage. He didn't. That was missing in the deal. And he got all this overtime and the missed meal breaks and the rest breaks, a lot of money. And he made a lot of money, got more money. So it's very important that you have a salary as well as any other formula that you pay people based on. Very important. Okay. Oh, this is kind of interesting. Another again, where we're seeing, by the way, lawsuits, and we're seeing lots of lawsuits. And the goal is for you not to win a lawsuit. Because winning a lawsuit is still going to cost you $150,000 to $200,000. And if you have insurance, you're still going to pay $15,000 deductible, and they're going to drop you afterwards. You want to avoid the lawsuits. Okay? It doesn't matter that you're right, and I'm going to win. You got to avoid them. So the big areas they're fighting now is the exempt versus non-exempt. That's the big area. You treat them exempt and they're really not. And misclassifying employees, independent contractors. Those are the big areas of lawsuits. So this was Safeway. They had a assistant manager. And she said, I was treated as exempt and I was non-exempt. I want my overtime, rest breaks, meal breaks. And Safeway said, because she said, well, I would check. I would look the checking thing sometimes, and I would bag, and I would stock shelves. And Safeway's position was, well, you could do that as well as manage. To be an exempt employee under the management, executive thing, you have to spend more than 50% of your time supervising other people. And they said she can supervise while she's doing these things. And the court said no. No. If you're doing non-exempt and exempt at the same time work, it's treated as non-exempt work. And they lost a lot of money. And what's interesting is companies like Safeway and some of these other big ones, they got lawyers 24/7 telling them what to do, and they can't figure all this stuff out. So don't feel badly that you can't figure this stuff out. It's tricky stuff. So kind of interesting. Then the piece rate. This is also kind of weird. I don't know how the payroll people are going to do this. Piece rate. We're going to pay you per task, per job. This was actually a trucking company where they paid the drivers based upon a combination of mileage and tasks. And they paid you. And they certainly made more than minimum wage. There was no issue. However, they were not separately compensated for breaks. So a piece rate employee is non-exempt. They have to get 2 10-minute breaks. Well, if you're not paying them an hourly wage, where does that 10 minutes come in? Where do they get their free 10 minutes? If they get paid for the job. So you need to actually compensate them for 2 10-minute periods if they're full-time. And maybe the pay stub has to show 20 minutes. And you got to figure out what their rate of pay is based on their piecework, and you got to pay them for 20 minutes. I don't know how the payroll people are going to show that. Because think about it, otherwise you're not getting paid for your rest breaks if you just get paid by the job. That's kind of weird. All right. Now, this is something just not to do. A company, who would do this? But a company, they told their employees, you know what, if you tattoo our logo on you, we'll give you a 15% raise. So 40 employees did. They said, we're going to do that. Who knows? Is that a good idea? Doesn't sound like a good idea. So what happens now? Do you now change the at-will nature of the contract? Now, I'm wearing your logo. Now I got a job here for life. What if you fire the person? Can you require them to remove the tattoo? Can you tell them where the tattoo has to go? But I thought it was interesting. And how do you give them raises? And you got to have more tattoos. It was a stupid thing. It came to our attention, and I'd recommend don't do it. I don't know. Besides, I got all these people now walking billboards. No, don't do it. Discrimination. Oh, discrimination is another big area. Discrimination claims. That's another big area where they're going after employers. There was a young woman, African-American woman, who this company said, we're going to hire you. You did well in the application, but you got to cut the dreadlocks off. We have a very professional grooming policy here. This is not professional looking. She went to the Equal Employment Opportunity Commission. EEOC is very involved in these things, and they said that was racial bias. You cannot pick a hairstyle that is kind of related to one particular race and say they can't have that hairstyle. Okay? So grooming practices is a whole other area. Couldn't do it. This is one of my favorites. We know that the ADA, right, Americans with Disability Act, you've got to make accommodations for people with disabilities. Right? You've got to make reasonable accommodations. Stress is one of them. And Ted's going to talk about a whole list. There's a whole bunch of new ones, but stress is one. This was somebody who had the stress of fear of being fired. This was a teacher. And she had a performance review, and he said, we're going to put you on probation, and we're going to observe you. Putting her on probation caused a great deal of anxiety and stress. Fear of being fired. And so she had doctors come back and say, you can only observe her, once every 2 weeks. You got to allow her to play soothing music and listen to that. You got to allow her to take breaks and bring another teacher in there where she has to go lie down and rest. You have to give her a relaxation area to go to because stress. But the stress comes from fear from firing. So what does that mean when you give an employee now a bad review? Of course they're going to have stress, right? So what's the reasonable accommodation now? Sorry. Weird. So watch that. I mean, I don't know. Because you're supposed to tell people you're not doing well. Oh my God, now I'm all stressed out. So be careful about that. A couple more. Religious. A couple of interesting cases. We know now with the Workplace Religious Freedom Act. Workplace Religious Freedom Act is supposed to make reasonable accommodation regarding people's religious beliefs as far as dressing, grooming, facial hair, you don't know, wear yarmulkes, crosses. If it's their religious beliefs, you're supposed to make reasonable accommodation. Okay? And you have to make reasonable accommodation unless it's an undue burden. Undue burden. You have to show it's going to be really costly and expensive for me to make these accommodations. So two interesting cases. One was, it's been in the news lately, Abercrombie and Fitch. There was a young woman, a Muslim woman, she wore a hijab, and she was in the back working. They hired her to go in the back. She wanted to work in the front. So one of the managers there said, yeah, come in the front. Supervisor came and said, no, you can't be in the front. You got to go work in the back. Because we have a look. And if you look at all the people on the walls of Abercrombie and Fitch, they're not wearing those things. And we don't like it, so you got to go in the back. She sued, and obviously she won. So a reasonable accommodation is not segregating people. Hey, we gave her a job, paid her the same. That's not a reasonable accommodation. You know, you could wear it, but you got to go in the back. So she lost on that. You'll see, got a big time on Abercrombie and Fitch. This was interesting about religious accommodations. First of all, religion is anything you want it to be. Doesn't have to be a church down the street or a church of a religion you've ever heard of. I don't know if you've heard of the Church of Body Modification. That's a religious belief. Well, I'm going to tattoo and pierce and put all kinds of stuff on my face and body. That's my religious belief. What are they going to do? Right? I mean, that's a whole other story. But this was a guy that came and said that his father died and he has to go back to Africa for 4 weeks. He only had 1 week's vacation left, so he wanted 3 weeks unpaid leave. He said, I have to go back to Africa and perform these rituals. That's a tradition in my family and our religion. We'll have to do certain things for 4 weeks there, or all the children of my father will die. Okay? So we have to go do this. The company said, I can't lose you for 4 weeks. You know, I need you here. You can't go. So he went anyway, got fired. The court said, you know what? That's his religious belief. It was not an undue hardship. You could have got temporary help. There's something you could have done. You had to make accommodation. So, you know, even if something sounds, I never heard of it before, that makes no sense to me, and you can't ask too many questions about it. So that's a whole other interesting thing. Okay, so Ted now is going to talk about some of the other ADA things.
Okay. Good morning, everybody. I'm Ted Schneider, Roy Schneider's partner and son. And I'm just going to pick right up where Roy left off. He mentioned a little bit about the ADA, the Americans with Disabilities Act. I'm going to give you something now that's going to be a little scary. The ADA covers now all new or old mental disorders. There's something called the American Psychiatric Association DSM-5. That's a diagnostic, it's the manual that psychiatrists use to diagnose mental disorders. And the disorders that are in the DSM include unspecified intellectual disability, unspecified depressive disorder, binge eating disorder. The list goes on. So what is unspecified intellectual disorder? You're just stupid. And now that is a disability. Being stupid is now a disability that you have to accommodate. Mood. An employee's mood is now considered a disability. Someone might be very irritable, very angry, flies off the handle. Well, that person might have bipolar disorder. You have to accommodate that. So what do we do about that? Well, the key here for most disabilities, not necessarily the mental disabilities, is making sure that your job descriptions are extremely specific. Because what are your obligations if someone has a disability? Your obligation is to engage in the interactive process with the employee to determine whether there is a reasonable accommodation that you can make that will allow that employee to continue to perform the essential functions of his job. Well, how do you know what the essential functions of his job are if you don't have a very clear job description? And we can help you with those job descriptions. It's very important. For example, a job description that simply says you may have to work in the warehouse doesn't really help you if an employee says that they have a physical disability. You're going to have to come up with a reasonable accommodation, and you'll still have to hire that applicant. But if your job description says, well, you're going to need to crouch and kneel at least 20 to 30% of your time, you're going to need to be able to lift 20 pounds at least 10 times a day, you're very specific. Well, now you can say, well, this person is not qualified. Even though they have this disability, which is protected, they're not qualified to perform the essential functions of this particular job. So very important that you have those job descriptions. And then on top of that, it's very important that you remember to engage in the interactive process. So if you have an employee, the employee now, the new law is the employee doesn't even have to tell you that he or she has a disability. If it is reasonably apparent, and that includes the mental disabilities, if it's reasonably apparent that this employee is just an idiot, you have the obligation now to engage in the interactive process, because you should be on notice that this employee has a disability. Obviously, if the employee is in a wheelchair, you're on notice. But sometimes it's not as easy. And the employee doesn't always tell you. But you still have the obligation to engage in the interactive process. And again, job descriptions are important because the whole point of the interactive process is to make sure that you can you accommodate this employee and still perform the essential functions of the job. In addition to the importance of the job descriptions and the interactive process, this is another example where the EEOC, yes?
Well, previously some of the compulsive disorders weren't covered?
Yes, well now they are. Now they are. If they're in the DSM-5, they are considered covered by the ADA. So obsessive compulsive disorder. So let's say someone has an obsessive compulsive disorder, they have to wash their hands, 10 times an hour. Maybe you have an accommodation, you have to put a sink in their workstation so they can wash their hands all the time. I mean, these are the kind of things you're going to have to be looking at.
Compulsive gambling and hiring and...
Well, those are more extreme, but again, we'd have to look at it on a case-by-case basis to see. And then also there's always the undue hardship piece. If really it is an undue hardship on the employer to make the accommodation, then you don't have to do that. But that's a very high standard. Yes?
Yeah. Are there no protections for the employer under the at-will contracts?
No. But because, yes, of course, all these employees are at will, but you can't fire an employee because they have a mental disability or a physical disability that's covered by the ADA. For example, so this is another reason you need to, yes?
In your job description, can you say ability to be able to concentrate for 4 hours a day?
Yeah, if you can prove that that is an essential function of that job, it depends on the job. I mean, if it's a car mechanic, you're going to have a hard time showing that it's an essential function of that job to be able to concentrate hard for 4 hours a day straight.
So you have to concentrate to do any work?
Well, I mean, we can go down. I mean, it's a case-by-case analysis. Yes, sir.
We talked about the interactive process.
Yes. Excuse me? Yes. So the interactive process is the employer's obligation, once the employer is on notice that the employee has a disability, to approach that employee and find out whether there is anything the employer can do to accommodate that employee's disability so that the employee can continue to perform the essential functions of his job. You have an obligation to engage in that dialogue. Yes, Mr. Smith, I understand you have X disability. Rather than just firing him, is there anything we can do to accommodate you so that you can continue to do your job? And this is where the Children's Hospital, you'd think of all places that would have not done this, you would think Children's Hospital, but the EEOC hit Children's Hospital hard last year because they actually had an employee who had a disability. She actually had cancer. She had lots of surgeries. She was out for over 6 months. She had a double mastectomy. She had her fallopian tubes removed, her uterus removed, all these surgeries. And she asked as a reasonable accommodation for 2 more months of leave. She had already taken 6. And Children's Hospital said, no, our policy is 6 months, and that's it. You're fired. You don't get any more leave. Well, they lost that because even if the employee has exhausted all of her leave under the employer's policy, you still have the obligation to engage in the interactive process because maybe giving her those extra months was a reasonable accommodation that would have allowed her to come back and perform her job. Extra time off is a reasonable accommodation. So they lost on that one. On the same vein, talking about disabilities. So here we are, we know the general rule is you can't ask a job applicant, do you have a disability? Well, does anybody in this room work for the perform contracts for the federal government? Is anyone a federal contractor? Okay. Well, these new rules are very important for you to understand because if you are a federal contractor, and these rules take effect actually March of this year, federal contractors now have to ask employees, are you, or applicants even, are you a veteran and are you disabled? Because the Office of Federal Contract Compliance Programs, the OFCCP, has a new mission that they want more veterans and disabled people working for the federal government. So they are now requiring federal contractors to ask their applicants, are you a veteran and are you disabled? Which seems to go against what we've always learned, which is you can't ask an applicant, do you have a disability? So we're going to have to see how that plays out, what that means for particularly California employers, where we have a law in California that is a completely opposite of that. So we just really need to pay attention to that. And if you're a federal contractor, you should come talk to us. Yes?
Your division of employers, does it break down into separate areas like federal versus non-federal employer and large employer versus small employer?
Yes.
Does the law break it down according to those?
Yes. Now, the ADA stuff that I'm talking about will apply to everybody. But there are different laws, different leave laws particularly. For example, the FMLA and the CFRA only apply to employers that have more than 50. So, but then there are other things like pregnancy disability leave, which applies to employers that have as few as 5. So you're going to have to look at the different laws to determine whether or not the particular law applies to you if you're a small employer. If you have more than 50, everything applies to you. Oh, so on the topic of reasonable accommodations. So what are reasonable accommodations? You know, I made the joke about putting a sink in someone's workstation because they have OCD. Maybe it is. Working from home has been ruled to be a reasonable accommodation. Even if you don't have a work-at-home policy, your company does not allow people to work from home. Well, if an employee has a disability, and that employee can show you that if I work from home, I'll be able to still perform the essential functions of my job, well, you're going to have to let that employee work from home. And again, this comes back to job descriptions. Job descriptions. If your job description is very clear that working from home is just not going to work, then you're going to be okay there. But you're going to have to look at the job. You know, a retail salesperson, not going to be able to work from home. You're not going to be able to perform the essential functions of your job, selling clothes, from home. If you're a CPA, where you spend maybe 90% of your time behind the computer, well, working from home, you may still be able to perform the essential functions of your job. So, again, these are things you're going to need to look at. And again, very important, is being present in the office an essential function of the job? Is that part of the job description? Paternity leave policies. This is interesting. Now, a lot of we try to make we advise employers not to have maternity and paternity leave policies because this California law will give certain employees the right to take leave for pregnancy and bonding with your baby. However, if you do have a paternity and maternity leave policy, like CNN in this case, where they actually provided paid leave, you're going to have to be very careful that that leave does not favor women over men. In this case, a worker for CNN sued Time Warner, the parent company, alleging that women were given, 10 weeks. Women were given 10 weeks of paid leave for maternity. Men were only given 2. Discrimination. Can't do that. Unless it was related to the fact that the woman is actually giving birth to the child and there's a disability component there. Obviously, women could take off more time if she needs to recover, etc., like from the pregnancy or from the birth. But a man, he has to have the same amount unless it's related to the disability aspect of pregnancy. And here, CNN's policy was particularly bad because it said 2 weeks for biological fathers. But if you were an adoptive parent, you get the 10 weeks. So definitely, watch out for things like that. Yes, sir.
I don't know how to couch this question, but does marital status have any bearing on paternity and maternity? If you're the father of the child, whether you're married to the mother or not, you would have the right to take time off to bond with that baby under CFRA if you have more than 50 employees. But marital status does not. So what are some other accommodations that you might need to make for disability? Roy was just telling you about the teacher that got stressed out because she was worried that she was going to get fired. Well, here's a case where a hotel desk clerk had anxiety. He got panic attacks. So he brought an assistive animal to work with him at the hotel. The manager of the hotel didn't like that. Said, this is a 4-star establishment. We can't have this dog here. Although it didn't actually say in the case what the animal was, but it's usually a dog. Maybe it was a parrot. I don't know. But so the manager cut the hotel desk clerk's hours. The desk clerk sued. And the EEOC sued on his behalf for retaliation. And so what does that mean? If you've got an employee who has panic attacks and anxiety and they want to bring their therapy dog to work, guess what, folks? You're going to have a little water dish set out for your employee's dog.
On that, what about the therapy? There's other people allergic to the therapy dog.
Well, then you're going to have to analyze, is it an undue hardship on the employer to allow the dog? So that's all going to have to come into the analysis. But obviously we knew the rule that if you're blind, you need, a seeing eye dog. Clearly ADA requires that you permit that. But now it goes beyond seeing eye dogs. It's therapy dogs for emotional distress.
Do you require an IME, independent medical examination, if somebody says I'm depressed and an animal?
I don't think so.
So you can't even ask to go have a doctor check you out?
I think you can't ask them to go see your doctor. You have to rely on their doctor. You can ask for a doctor's note. Absolutely. But as we all know, you can get anyone can get a doctor's note from anybody that says anything. Yes, sir.
You allow that accommodation, dog bites and
Yeah, it's a very good question. You are. You are. So, I've mentioned the EEOC a couple times. This is important. The EEOC has just issued something called their Strategic Enforcement Plan. What have they targeted in their Strategic Enforcement Plan? Well, they have specifically targeted equal pay for women. So this is a big one. And EEOC actually went after a big fast food chain recently because they were able to show that the female employees were being paid at a lower rate than the male employees. And the EEOC was able to show that, for example, when the restaurants got slow, it was the female employees who were sent home, not the male employees. That is a very big no-no. You've got to always be cognizant of making sure that you're treating male and female
exactly equally. And let me tell you, the EEOC is no joke. 2013 was a record year for EEOC enforcement actions against employers. Over $372 million in 2013 alone recovered from employers for retaliation claims, wrongful termination claims, ADA claims. So it's not just the employee you have to worry about, but the federal government is going to be knocking on your door too, $370 million. You don't want to be one of the employers that helped contribute to that total. Another area that the EEOC is targeting is mandatory retirement ages. This is a little interesting, may not be that relevant to many of you here, but we represent companies that do have mandatory retirement ages, and in this case, this was PricewaterhouseCoopers. They have 60 years old, you have to retire, whether you want to or not. Well, is that legal? The EEOC says no. That case is now pending. And the question there is, normally partners in a partnership, whether it's a CPA like PricewaterhouseCoopers, law partnership, whatever it happens to be, partners are not employees for purposes of all these laws. However, the EEOC is arguing, well, if you're, let's say PricewaterhouseCoopers, they probably have 1,000 partners. And there are some who are way down with like maybe just a little tiny partnership interest. And they're really treated like employees. They don't really have a lot of say. So if you have a partnership where you have a number of partners and some partners really don't have a lot of say or control, they may be protected against discrimination, ADA, age discrimination, as an employee, even though they're your partner. We're going to have to find out what the court ultimately rules in that case. But another thing to watch out for. Okay, and now Roy's going to go talk some more about what the feds are doing to us.
No, the government is very, very active in this. One comment on the interactive process. You should keep in mind that the interactive process, failure to do it, is a separate claim. It's a separate cause of action. So even if it's clear that there's no way you could accommodate this person, just can't be done, you could prove that, but you didn't engage in the interactive process, that's a claim that will survive in the lawsuit. So it's very important just to be overboard on that and really, talk about it.
So an interactive process, could that include a three-step process where there's a verbal warning, a written warning, and
no, the interactive is not the discipline. Interactive is accommodation.
So is a disciplinary process part of considered interactive?
No. Interactive only is what can we do to make it easier for you to work. Not discipline. So it's based upon people only with disabilities. That's the only time it comes into play, really. Disabilities, and we'll learn a little bit of the stalking and things like that.
Well, a disability claim relative to some of these emotional issues might surface as a discipline.
It could end up. Sure. And it's difficult. No, it's very difficult. There was a case not long ago where somebody had a job review end of the year. They were very unhappy with their review. They picked up a chair and they threw it in the office. Got fired. And they brought a suit saying, you knew I was bipolar, and that's a reasonable accommodation is I got to be able to throw chairs. So I don't know what you do with that. And she won, got money. Because you didn't make reasonable accommodation. I don't know how you do that. What if you have an employee who's got like little fits and gets violent, likes to hit people? So what you do is usually find somebody who works there and who nobody likes and say, if you ever want to hit anybody, hit him.
Your employee manual covers drugs, but when you have somebody that is mentally, they're being treated by drugs, then the HIPAA laws come into play because maybe you can't ask, what do? Do you ask for a doctor's note? Do you expand your description of drugs in your employee manual?
Well, what kind of drugs? You mean like prescription medicine?
I have had some that were on such heavy drugs that it made it very hard to do their job, almost hard to stay away.
Well, if the job description is clear enough where they can't perform the essential functions for whatever reason, then you could talk to them and say, are you having difficulty? what can we do? They may say, I need a week off, I need to work only 2 hours. You have that discussion, okay? And that's what you got to kind of do.